Lord Beecham.
My Lords, I declare an interest as an unpaid consultant in the firm of solicitors which I was previously senior partner and which practices in part in the area of legal aid. My Lords, we follow a debate on human rights with a debate on one of the most fundamental of human rights, that of access to justice. I should say immediately that the credit for this motion coming before your Lordship's House today belongs not to me but to my noble friend Baroness MacDonagh, who drafted it and who would have presented it had she been able to do so. Alas, she is not able to be present today for personal reasons, so I am in a sense instructed by her, which is a familiar condition for me because she used to instruct me on behalf of the trade union for which she was an officer many years ago, and after that as General Secretary of the Labour Party. I follow her instructions today with perhaps a little more alacrity than I did in that former case. My Lords, the legal aid system was one of the great pillars of the post-war welfare state. At one time, affording access to justice to 80% of the population, it has, of course, undergone many changes in the last 62 years. Currently, around 36% of the population fall within the financial eligibility limits, both income and capital, for legal advice and assistance or representation in matters of civil law. Some areas have long been excluded from the civil legal aid system, including most personal injury claims, removed from the system's scope, ironically, because of the very conditional fee system which the government now proposes to abolish in the guise of an attack on the so-called compensation culture, whose extent is surely exaggerated. My Lords, last week I confessed to having form in the matter of police reform changes. I have a similar confession to make in respect of legal aid because, as my noble friend Lord Bach will recall, I was responsible for a debate at a Labour Party conference which was somewhat critical of the previous government's legal aid policies, just before he became a minister with responsibility for them, and chaired a very constructive working party which made some improvements to that policy. So at present we have legal aid and advice available across a wide range of issues, from debt to employment matters, housing, education and family law, immigration and clinical negligence, and more besides. In some of these, legal aid does not extend to representation, in others it does. And the total cost is around £900 million a year for civil legal aid and £1.2 billion for criminal legal aid. The government's Green Paper on legal aid reform proposes a massive cut in the civil legal aid budget of some £279 million, with a much smaller reduction of around £71 million in the criminal legal aid budget. It achieves this by substantially reducing the scope of the scheme across most of the categories currently covered, and in several it removes it entirely. The effects, my Lords, are stark. The government's own assessment of the number of people, that's to say individuals, not the numbers affected by the withdrawal of access, for example family members, is around 500 to 550,000. This figure appears to understate the real effect by around 150,000, based on the latest Legal Services Commission data, which shows that some 725,000 people will be denied access, or cases will not be assisted. It's fair to say that the Legal Action Group's estimate is 650,000, still substantially more than the government's estimate. And those figures, no doubt, reflect rising demand stemming from the effects of the recession, both in terms of the need for advice and increasing numbers becoming financially eligible. So what, my Lords, are the implications of this massive cut, around 70% in the number of cases for which funding would be available? In round figures, there would be 250,000 fewer cases involving family disputes, 140,000 fewer cases involving welfare benefits, 110,000 involving debt, 50,000 with serious housing problems, 30,000 affecting employment problems. And the impact of all this is concentrated on the poorest. Currently, 80% of legal help cases and 90% of cases where legal representation is funded involve the poorest 20% of the population. Others of your Lordships will no doubt give examples of the kind of cases for which assistance will no longer be available. I just want to confine myself very briefly to four. In housing, tenants will not receive help in securing the repair of their homes. In education, the parents of disabled children will not be helped to secure proper provision from their education authority. In employment, help will only be available in discrimination cases. And in the complex world of clinical negligence, no claims will be assisted, not even for children. The government believes that greater reliance on two factors, mediation and the support of voluntary organisations, will substantially mitigate the effects of these draconian cuts. But, my lords, mediation already exists. It has to be considered by the parties and the courts now. And yet only in some 4,000 cases a year is it adopted. Moreover, as I remarked when we discussed the statement launching the Green Paper, mediation is not suitable when, as in many family cases, there is a disequilibrium in the resources, material or psychological, of the parties, with the pressure on the weaker party to agree often being irresistible. And the object of mediation, by definition, is agreement, not adjudication. And as to alternative sources of support, such as law centres or Citizens' Advice Bureau, they too are under extreme financial pressure, both from the withdrawal of government funding implicit in the proposals of the Green Paper and from local councils struggling to cope with the largest ever reduction in government grants. The Law Centres Federation alone anticipate a loss of something over 50% of law centres' income, and there's a real fear that 50 out of the, I think it's 56 existing centres may be forced to close if the Green Paper proposals are implemented. Many are already struggling with cuts in grants from local councils, such as Birmingham or Hammersmith and Fulham, where the entirety of local authority funding has been withdrawn. And Citizens' Advice Bureau face similar pressures at a time when demand is increasing. Now, my lords, the government claims rightly that our legal aid scheme is one of the most, if not the most, generous internationally. But as the Bar Council points out, if one looks at the cost of the justice system as a whole, adding the costs of the courts to the legal aid bill, the gap is much narrower. Reducing the cost of administering the system should be the first priority. Paradoxically, the reduction in legal aid and advice might well drive up costs as the courts contend with the problems of dealing with litigants in person. In any event, international comparisons of expenditure are inevitably rough and ready, taking little or no account of different legal systems, let alone different social and economic structures or pressures. Moreover, my lords, the Citizens' Advice Bureau and its evidence, and its response rather, to the Green Paper, demonstrate that the taxpayer actually saves substantially by investing in legal aid. In housing, the saving is £2.34 for every pound spent on legal advice and legal aid. In debt, £2.98 for every pound spent. In benefits advice, £8.80, and in employment, £7.13. Now, my lords, clearly the justice system cannot be immune from the pressure to engender savings at a time when deficit reduction is a given, even if the scale and timing of reductions continues to be contestable issues. I urge the government, however, to consider very carefully the Law Society's proposals for savings. The Law Society identify £249 million worth of savings for the Ministry of Justice from a range of measures, including improving the efficiency of the prosecution service to capping an individual's fees, an individual lawyer's fees, derived from legal aid. In addition, it accepts £62 million of the savings that the government propose in the Green Paper, plus further savings from barristers' fees. I have to observe that Law Society is rather quick to suggest reductions in barristers' fees, which may not necessarily be shared by the Bar Council. In addition, it suggests areas where revenue can be raised, for example, by a modest 1% levy on the alcohol industry, which contributes significantly to the need for legal services, not just in the criminal courts, but in such areas as family law, housing, debt and welfare, or, on another track, by simplifying housing law. They estimate that £158 million could be raised from a variety of such measures. Now, if all the savings suggested by the Law Society were to be implemented, that would bring a total of £469 million worth of savings, actually substantially more than the government's proposals as contained in the Green Paper. But there may be other ways of contributing to reductions on the civil legal aid budget. In earlier days, legal aid lawyers suffered a levy of 10% on their costs, as eventually assessed by the courts or agreed with the other side. Perhaps we could revert to that system and generate money for the legal aid fund. Or perhaps we could introduce a contingency fee system under which legally aided clients would contribute a proportion of the damages or sums they recover to the legal aid fund, though preferably not to their own lawyers. I recall once suggesting such a scheme at a meeting where my noble friend Lord Beecham, then a minister in another place, had roundly denounced fat cat lawyers. Speaking, as I said at the time, as a moderately plump cat lawyer, I thought my proposal worth investigating. He didn't, and it wasn't. Yet it still seems to me that such a system, coupled with what used to be the practice that cases had to be independently assessed by practitioners as having a reasonable chance of success and authority to obtain to incur significant expenditure, that would be better than the conditional fee system, which was supposed to incentivise lawyers to undertake weaker cases on the grounds that swings and roundabouts would apply, many of which might well fail, and those cases would be subsidised by the fees on those they won. But of course the conditional fee agreement is now to go. My Lords, the Lord Chancellor has made a refreshing start on reforming penal policy, distancing himself from both his Conservative and Labour predecessors. I applaud him for that, though not for yesterday's unfortunate pronouncements. But in this area of civil legal aid, he is in danger of making a grievous error. In the words of the current Lord Chief Justice, the proposals fail to recognise the depth of the problem. The proposals would lead to a huge increase in the number of unrepresented litigants, with serious implications for the quality of justice and for the administration of the justice system. Or consider, my Lords, the following from the Jackson report, from which the government has cherry-picked recommendations about costs and conditional fee agreements. I do not make any recommendations for the expansion or restoration of legal aid. I do, however, stress the vital necessity of making no further cutbacks in legal aid availability or eligibility. The legal aid system plays a crucial role in promoting access to justice at proportionate cost in key areas. Those are very salient words from a distinguished judge looking at this key issue of public policy. My Lords, I have quoted the present Lord Chief Justice. I conclude by referring to a most distinguished predecessor, the noble and learned Lord Wolfe, who is not in his place today. 2 or 3 years ago, the noble and learned Lord published a volume which is a distillation of his prudence, wisdom and humanity. It's called The Pursuit of Justice. The title is derived from the biblical injunction, "Justice, justice shalt thou pursue." My Lords, I hope that this House, in the course of this debate, will endorse that sentiment and urge it on the government.
Yeah. Question, is this motion be agreed to?
My Lords, I should begin by declaring an interest as a practising barrister and also as chairman of research for the Society of Conservative Lawyers and editor of a pamphlet submitted to the government, to the Ministry of Justice, as part of the consultation process in relation to the government's proposals for the reform of legal aid. Lords, the government must cut £350 million by the year 2015. Although comparisons are not easy, we spend much more on legal aid than countries of equivalent size and economic status. Legal aid, with other areas of government spending, must bear its share of pain. I agree with the government that resort to court proceedings should be very much the last resort, and that encouragement should be given to people to seek remedies by other means. The party opposite has accepted that had they been in power, and I rely on what the Shadow Minister Sadiq Khan in the other place said, there would have had to have been significant cuts in any event. However, consistent with their approach generally, there has been a lack of specificity about where those cuts might fall, thereby leaving plenty of room for manoeuvre to criticise the proposals that the government has put forward. However, I welcome the noble Lord Beecham's debate and give credit to him and Baroness MacDonagh for initiating it. If one accepts that cuts have to be made, the question is where the axe should fall, so as to cause the minimum of pain, and to try and ensure, so far as possible, that there remains meaningful access to justice. I share the concern, I suspect, of many noble lords that the vista of unrepresented litigants will not necessarily be much of a saving in terms of the administration of justice. Cases tend to take longer, and sometimes there are appeals on difficult points. My Lord, there is a little time to deal with all the many issues that the government's proposals involve. May I just refer to two? The first is the question of clinical negligence. Some clinical negligence cases are, of course, of immense complexity. To take an example, an obstetric case, which may result in a brain-damaged baby. These cases will involve a myriad of experts, quite rightly. Expert witnesses such as obstetricians, midwives, neuroradiologists, paediatric neurologists, neonatologists. A great deal of expertise is needed from them and from the lawyers to investigate what is often a very difficult matter, whether there has been a departure from the appropriate standard of care, and often even more difficult, whether such departure has or has not caused damage. Enormous amount of literature has been generated by this. It really does involve a great deal of skill. Very often the conclusion is reached by lawyers that there is no case, the matter does not go forward. There is not to be any legal aid at all, even for the investigatory steps, which I would suggest is potentially going to cut off some very important cases. It means that those who really need compensation in the years to come may well be denied. The government's answer is the CFA system, but because of the changes in the CFA system which they propose following Jackson, the partial implementation of Jackson, this means that it is going to be very unattractive for many lawyers to take these cases. The limits to the success fee, 25% of damages excluding the really sizable amount, and no recovery of after-event insurance, means, I fear, that many firms are going to restrict their activities to very straightforward cases of egregious errors, the sort of cases, in fact, which will attract claims managers rather than responsible and experienced lawyers. So may I suggest to the Minister that if he does nothing else from the result of my observations, he goes back to Sir Rupert Jackson and asks him whether, in fact, he would approve of this effective pincer movement between those very worthwhile cases which are going to be prevented as a result of the government's changes. The second point I have to deal with very briefly. It's this. The tone of the government's response seems to suggest that there is some possibility of additional funding in cases where they may feel that they would be in breach of treaty obligations if they did not do so. I take this, reading the subtext, to be a suggestion that anything to do with Human Rights Act cases may still require legal aid. There are some very important Human Rights Act cases, but let me tell the House that there are an enormous amount of very trivial Human Rights Act cases. The government should not be frightened to say that if these cases are not serious, they do not involve large amounts of money and are not truly human rights issues, there should be no legal aid for this. There should be savings which should be better spent elsewhere.
My Lords, I wish to focus on one particular aspect of the government's plans for legal aid, the proposal to take social welfare law out of scope. My Lords, of the cuts to be made, over 100 million will be cut from the social welfare legal aid, and as a result, most social welfare law and legal advice will no longer be covered. My Lords, I want to draw attention to the context in which these proposals are being made. The Welfare Reform Bill is currently making its way through another place. Its proposals are frankly, a revolution in welfare benefits. Even the DWP, and not given to overstatement, described the bill as being the biggest change to the welfare system for over 60 years. The bill will abolish most of the income-related benefits we know about: income support, job seekers allowance, employment and support allowance, tax credits, housing benefit, council tax benefits. All of these will go. They'll be replaced by a single benefit called universal credit, many of whose key features are not yet clear, even though the bill is about to come out of committee in another place. There will also be other changes, more conditionality for people already in jobs. The noble lords will be aware of tests being used already to determine if people are entitled to disability benefits. There was a dramatic change, a shift in local decisions on a range of benefits and provision, and there are proposals on the table which would significantly reduce access to the statutory system of child support. My Lord, those proposals combine together to change the landscape for poor people very dramatically over the next few years. But my concern is, when governments make changes on that scale, mistakes happen. Inevitably they happen. It takes time for those administering these new systems to calibrate the decisions that they make. It takes time to understand whether new systems will in fact achieve what they were meant to achieve. Many of the decisions that are made turn out in practice to be good, others turn out not to be, and it's often having those tested in court or in tribunal that helps governments as well as the individuals to understand what it was Parliament intended. My Lord's, benefits law is very complex. The new system may be integrated, but anyone who's read the Welfare Reform Bill will know that will not make it simple. It will simply make it integrated and complex rather than separate and complex. But, my Lords, if someone is to challenge a decision, if they have their benefits rejected, or if they're stopped or sanctioned in some way, they're going to need advice. The evidence is quite stark about the difference in success between those who are represented and those who aren't, something that will presumably come as a relief to the many lawyers around your Lordship's house. But, my Lords, given all those changes, does this feel like a good time to be stopping providing advice and help to benefits claimants in those settings? I think not. Also, as well as the fact that benefits recipients themselves generally tend to be poor, legal aid, of course, is targeted at poor people. Therefore, these changes clearly target the poorest people in our country. I'm also concerned, my Lords, as the CABs have pointed out, by the fact that the shift in the criteria for civil funding is moving towards crisis points, such as imminent homelessness, and away from the kind of legal help and advice which might prevent someone becoming homeless in the first place. My Lords, that doesn't seem a sensible move. My Lords, ensuring the rule of law, as is often observed, is one of the foremost duties of the state. But a citizen who can't challenge a wrong decision by the state simply because they haven't got the money cannot depend on the rule of law. My Lords, that does not mean unlimited spending on legal aid, but I think it does mean not removing from scope an entire aspect of publicly funded legal support, an entire aspect of law which is fundamental to the dignity and survival of some of our poorest citizens. My Lords, when the Welfare Reform Bill comes to this House, I hope very much that the considerable expertise around these benches will be deployed in scrutinising it very carefully. It's a substantial piece of legislation. The changes will make a big difference to the lives of the millions of people who depend on benefits. My Lords, it's the kind of thing this House does very well, and I'm sure the bill will not emerge in the same state as it came in. But, my Lords, what is the point of our spending weeks of parliamentary time scrutinising legislation if in practice those who are affected by it have no means to ensure that Parliament's intentions are implemented? My Lords, I would ask the Minister to consider one thing in particular. If the Government will not move on these reforms in general, would he consider at least making no changes to the provision of legal aid, advice and help to those affecting benefit claimants, at least until 2 years after the Welfare Reform Bill has been implemented in full? My Lords, the very least people expect is that Parliament makes decisions, they should be able to get justice according to them.
My Lords, there's no point in cutting legal aid if the effect is to increase government expenditure in other areas and at the same time deny access to justice. The Green Paper proposes a radical reduction in the scope of private family law issues for which legal aid will be available. That policy is based on a false premise that spending on legal aid fuels litigation and that the only alternative is mediation. Family lawyers as a group are committed to settling cases out of court as expeditiously as possible, often by referring clients to mediation, but more frequently negotiating settlements themselves. And in my early days as a solicitor, I was much involved in that sort of work. The Green Paper entirely neglects the current important role of lawyers in non-court-based resolution of legal disputes, particularly financial and custody disputes. It's very probably because clients were able to see a solicitor that litigation was avoided in many cases. Without professional guidance, ill-founded and certainly ill-prepared litigation conducted by the client in person will inevitably follow. And that will mean a very substantial rise in the number of litigants in person in the family courts. Sir David Norgrove, the chair of the Family Justice Review panel, in his interim report published recently, has emphasised this point. Those who lack the personal energy and other resources to take on litigation by themselves would not get access to justice at all. Those who have not been able to enforce the other party's private law responsibilities for support and so on inevitably fall back on the state for housing and support, and so that's where more state expenditure is incurred. One reason why mediation is currently successful is that the threat of litigation encourages people to adopt sensible positions in mediation or in settlement discussions. With that threat effectively removed in many cases by the removal of public funding for legal representation, successful mediation will be very severely hampered. Now, legal aid is to be granted where there's physical violence. Well, there's an obvious perverse incentive for people to allege domestic violence just to get access to funding for their other issues. And the other side to the argument will say, well, I never did that. So that's going to increase more contested court proceedings. And many of the women who do not disclose domestic violence they've suffered or refuse to apply for injunctive relief in relation to it will not get a proper and safe resolution of the issue. So the very class of persons the Green Paper most wants to protect will be left unprotected and in potentially extremely dangerous situations. Domestic violence very often, only comes to light through the lawyer's handling of the case and learning it from the client who has kept it concealed from their family. Mediation in such cases will not work and should not be tried at all. Lords, may I turn to clinical negligence? Medical negligence cases have played a very important role in improving healthcare by setting standards, publicising deficiencies and punishing failures. The thalidomide case is a very good example of that. In many cases, new procedures have been introduced and developed as a result of litigation. According to the Green Paper, taking clinical negligence out of legal aid would save £17 million. Of the 500,000 avoidable incidents in England alone, estimated by the DOH in 2009-10, the National Health Service Litigation Authority received only 6,652 claims. Expert solicitors who handle these claims will decide in 75% of them that there is no case. Sometimes there's negligence but no injury, sometimes injury but no negligence. It is not possible to assess the chances of success in clinical negligence cases at the start of the case. There must be funding to find out if there is a case and funding for higher cost cases. I follow the noble Lord Fawkes when he pointed out that whether the issue is negligence or causation, expensive expert medical evidence is required to establish a basis for the claim before a decision to proceed is made. Now the government proposed to remove legal aid for clinical negligence at the same time as changing the no-win, no-fee agreements. I'm grateful to the noble Baroness Lady King, who pointed out to me that children who were said to be still covered for clinical negligence cases are not to be, and I'm sure she will expand on that. Sir Rupert Jackson, when he published his proposal, said this: "I stress the vital necessity of making no further cutbacks in legal aid availability or eligibility. The maintenance of legal aid at no less than the present levels makes sound sense and is in the public interest." So his proposals are based upon the continuing existence of legal aid. Removal of legal aid will deny access to justice to some of the most vulnerable groups in the country, the children, the sick and the disabled. And the need to streamline costs and for systems to be efficient should not be at their expense.
Noble Lords, this is another time-limited debate, and when the clock reaches 5, you've had your 5 minutes.
My Lords, anyone who's had elected office as a Member of Parliament or as a local councillor will know how important it is to be able to advise constituents to go to a local law centre, CAB, or even to legal aid solicitors. And it is perfectly clear that the government's proposals are going to hit the most vulnerable. All the figures point to that. 85% of the people who got legal aid were the poorest 20% of the population, and it is very clear that the vulnerable are going to be hit particularly hard. And of course there is specifically an even more shocking issue that there will be no more legal aid for children who are the victims of medical accidents or negligence. My Lords, it is very clear that early intervention when people have difficulties is a much quicker way of resolving their problems, and it's also more economic. If one takes the case of someone who gets into rent arrears, all too common, if they get advice at an early stage, that can be dealt with and they don't become homeless. If one leaves it too long, they become homeless. Yes, at that point they may get legal aid, costly for the public purse and awful for the individual who is concerned. And we've already had the statistics from a noble lord about the savings there could be by early intervention as opposed to leaving it late, and more public money has to be spent. My lords, I was shocked, as other noble lords were shocked, to learn that in the government's view, domestic violence is now to be the gateway to receiving legal aid in relation to family law. It seems to me this is turning the thing on its head, because where it is fear of violence that often is the key thing, more than actual violence itself. But certainly people can turn this thing on its head, and they can say that people are using violence in order to get the benefit, or they're making such an accusation. My lords, it is increasingly clear that the procedures governing immigration, education, employment, welfare benefit and so on are becoming more and more complex. Certainly, to go to a tribunal requires expert help and advice, and without that, most people will not be able to manage it. And of course, legal advice is also helpful in that it can persuade people that where cases have no merit, they don't proceed to a tribunal. So there's also a saving there. According to the Child Poverty Action Group, in 2010, there were 50 new statutory instruments regarding social security, housing benefit and tax credits. These are all such complex matters, and really it is very hard to see how people with the best will in the world can proceed to getting their rights without the help of experts. It is suggested by the government that telephone advice might work. It will for some people, of course. But when one thinks of people in difficulties, anybody who's had a constituency will know people come along with documents. They say, this is my difficulty, here I can demonstrate, these are the bills I can't pay, and so on. It makes the matter much clearer than it could be on the telephone. And of course, urging people to use telephone advice is going to be damaging to particularly the more vulnerable and the poorer social classes. Well, may I finish on one specific issue, and that's the question of forced marriages. I happened to go to a meeting here yesterday or the day before on the subject of forced marriages, and these concern women in the main who are very vulnerable, who usually have no money, and of course by definition their families can't help them because their families are often the cause of the problem. And what can these women do? Now, we have the Forced Marriage Protection Order, which can help. It can provide some protection. But frankly, to access that order without legal help is virtually impossible. It's quite a large problem. Estimates, of course, are difficult to come by with any accuracy, but the Forced Marriage Unit, the Joint Home Office FCO unit, had approaches last year from nearly 2,000 women, and other estimates suggest that forced marriages may affect up between 5,000 and 8,000 cases a year. But above all, the safeguard, or bit of the safeguard, is the Forced Marriage Protection Order, and I do not understand how that can be accessed without legal help.
My Lords, when I arrived in the Lord Chancellor's Department in 1998, my experience of legal aid had been limited to the pro bono activities of my firm, Herbert Smith, who, from a position of economic comfort, nevertheless looked across city boundaries to the much poorer London boroughs of Tower Hamlets, Hackney and Islington, and made contributions to, among other things, local law centres, and I'll come back to those in a moment. So it was only in 1998 that I realised the enormity of the legal aid problem, and that there was an asteroid with legal aid written on it advancing towards the Lord Chancellor's Department. Budgetary restraint, increasing year by year, meant that the greater priorities of health and education placed heavy restrictions on funds for legal aid, and this was compounded by the fact that the first claimed on such funds went to criminal cases where there was a priority to defend those who faced the prospect of loss of liberty. It was impossible to ring-fence a fund earmarked for civil legal aid, and yet when I began to make visits to law and legal advice centres and Citizens' Advice Bureau in the inner London boroughs, such as Tower Hamlets and Southwark, and to major cities outside London, such as Bristol and Nottingham, I was immediately impressed by the need for a greater investment in providing help and advice towards solving civil problems before they involve the courts. The spiral of decline, triggered by one event leading to another, was obvious from the case studies that I saw there. For example, loss of income caused by unemployment could lead to debt, which in turn could lead to homelessness, which could bring about marital breakdown and lead to domestic violence, then to ill health, short and long term, physical and mental, and to negative and harmful effects on children and their educational performance and future life chances. And of course the dominoes did not all fall at the same time, but the spiral is well documented, and I was particularly impressed by the pioneering work of Professor Dame Hazel Jen at UCL and her book Paths to Justice, and she was of great help to the department in my day. I also pay tribute to the selfless work of those in the law centres and agency who I observed at first hand. There were no handsome salaries to compare with the private sector, and many were volunteers. Local authorities were unable to offer much help, and it was left to us to provide the seed corn. The law centres correctly pointed out that early advice and intervention could help break the spiral of decline. It was also self-evident that each of the components of the spiral brought with it economic costs for society as a whole. It followed, therefore, that early successful interventions would not only save costs, but prevent problems escalating. A cost-benefit analysis outlined by the Citizens Advice Bureau in July 2010 seeks to demonstrate the advantages of early advice in respect of housing, debt, benefits, employment and family. In monetary terms, the benefits are enormous and are real value for money, vindicating the principle and justifying the amount of civil legal aid as a worthwhile investment. And I'm proud of the fact that the last government introduced the Community Legal Service, and notwithstanding the fact that they were faced with a growing need to effect savings in the legal aid budget, which they did, they always sought to protect social welfare law. And my lords, my fear now is that those that I saw making such a valuable contribution in providing immediate help to those in most urgent need of it will now be faced with a setback from which it will be difficult to recover. And in response to the suggestion that the voluntary sector will fill the gap left by the removal of civil legal aid in the proposed areas, I can see no evidence for such an assertion. The legal profession can be justifiably proud of their record of pro bono activities. They have provided millions of pounds in their endeavours in that respect, and I've checked my former firm's policy on what is now called corporate responsibility, and that of my wife's corporate responsibility plan at Norton Rose, and their impressive policies, like many of those adopted by other city firms and solicitors. But they just will not be able to cover the gap that will open up. And in spite of their outstanding achievements in their policies, even all of the city firms put together will not have enough to cover the expected shortfall in the inner London areas surrounding the city, let alone the rest of the country. And we must remember that local authorities are still strapped for cash and are unlikely to be able to help. And I hope the Minister will explain how advice deserts, as they have been called, in some of the most deprived communities in the country are to be avoided, because without more civil legal aid, I cannot see how they can.
My Lords, can I also thank the Noble Lord Beecham for tabling this timely debate. And I share the respect and admiration of the government for the voluntary agencies working in this area. But as the previous Noble Lord has said, it's very hard to see how they can meet the depth of need available. I'd like to concentrate, my Lords, on two issues. One is the separate representation of children in family courts. It's very important that when parents are fighting with each other, the child's voice is not lost. And I would like reassurance from the Lords that tandem representation of the type developed by the National Youth Advocacy Service is not denied children because of these cuts or changes. My Lords, I would also like to focus on the impact of access to justice for young people and adults who have experienced local authority care. Despite welcome investment and attention in policy and legislation, for many young people leaving care, they have still had an appalling experience. and this leaves them vulnerable in life to succumb to many of the problems that are being addressed today. But also many of them deserve redress for the way they've been disappointed. For instance, at a meeting yesterday of young people in care and care leavers, foster carers and social workers, we had a young woman talking about being separated from her siblings, still in care and separated from her siblings. We had another report of a young person who was an experience of a family siblings being split up among several different foster carers, and the anguish of the young person involved losing in touch with their siblings, and the sense for them that there was no real attention paid to their need to keep in touch with their brothers and sisters. My lords, we heard from one young man who'd had 21 or 20 different placements in his years in care. We heard another young woman who had 5 different social workers within the last two years. We heard of all the instability that continues in care. We also heard of the welcome report from Professor Munro, into social work and how that can be streamlined and improved. And I do pay tribute to the government for the efforts they're making, and the previous government. But there is a huge way to go. In particular, we heard from a young mother whose child had been removed from her. And we know that if a young woman is in care, she's far more likely to become pregnant in her teenage years, and that her child is far more likely to be removed from her. And this young mother had expressed a concern, that because her mental health needs had not been met while she had been in care, that was the reason that later in life her child had been removed from her. And it's very clear the evidence is that when children are taken into care, they've had trauma, they should be properly assessed by a psychiatrist or a clinical psychologist, and they are not currently getting that proper assessment. And then the specialists looked after children's mental health teams that have been developed in recent years are expensive, complex to run, and they are very vulnerable, and it's still only patchily in place. Many young people are not getting the support they need for their mental health needs in care. So this young mother went to the European Court of Human Justice over the case of her child being removed. And she went in person, and exceptionally the court accepted her case, consideration of her case. She emphasised this. We also heard at the same meeting a barrister who'd been in care speak about his admiration for a young person who'd gone to court to seek redress from his local authority for the way that he'd been treated, and his admiration for the way that that young person stood up for his rights. But, my lords, what I would like reassurance from the Minister on is that cases like these, where young people and adults who've been disappointed in the treatment they received in care, can have as powerful access to justice as they need to get the support, for instance, to get access to pay for counselling and therapy, or indeed for those sorts of issues. My lords, as I say, it's very important that children in the family courts, their voice is not lost, and they continue to have separate representation when that's appropriate, and also that there is every opportunity for young people leaving the care system, and adults who've experienced the care system, to get redress for the way that they've been denied their right to family life on many occasions, and for the treatment that the disappointing treatment they've often received.
My lords, normally I don't trouble your lordships on legal matters. They're way above my station. I normally speak on more lowly matters, such as business and industry and science and technology. But on this occasion, I feel that my noble friend's case is so strong and so compelling that I just wanted to show my support. So, with apologies to the noble and learned lords for trespassing on their territory, let me try and put this case in a way that we practical people see things. The first thing we look at are the numbers. Now, legal aid is a big number and is paid by a small department, the Department of Justice. Is this a true picture? In the world of business, we're pretty good at presenting numbers so as to project the impression that we want to give. Is this being done here? Many noble lords have spoken of legal aid in health, in housing, in employment, in criminal negligence. Surely these are matters for those government departments, not for the Ministry of Justice. And if the legal aid costs were allocated to these various departments, surely they would become much smaller. They'd become minuscule. So I put it to the Minister that if these costs were allocated differently, would the numbers tell a different story? Now, we technologists are very keen on understanding the theory behind things, how they work and why they happen. We like to understand the cause so that we can foresee the effect. And if there isn't a theory that we can't understand, we sometimes we rather think that there's something phony behind it. So what is the theory behind cutting legal aid? We know the effect, but what is the cause? And justifying it simply by the need to save money, as I think the noble Lord Fawkes was doing, is intellectually very weak. And it'll be to the lasting shame of this government if we come to look back on things and say the only reason they could find was because we couldn't afford it. So can the Minister be intellectually more robust and explain these civil legal aid cuts in terms of the rights and wrongs of civil aid, rather than in just saying that we can't afford it? Now, in my world, we're very keen on testing, both in theory and in practice. We're very suspicious of things that are done in a blinding rush before they can be tested, because, you know, this is the way mistakes are made. Now, we all know why this government is in a rush. They've read Tony Blair's book. And in his book, he says that his biggest regret is that he didn't get on with doing things straight away. What he didn't say in his book is that we spent a lot of time thinking and discussing our way through these problems, looking at alternatives, consulting and learning from other people's experience, trying out different ideas in white papers and green papers so that the best one won, so that policies like Sure Start came out of several false starts. Everybody in my world thinks that this is the best way of ensuring success, and I find that this careful preparation and testing absent in the attitude of the government towards civil legal aid. Surely those who depend on it deserve the fact that alternative solutions may be found, such as the reductions in costs mentioned by my noble friend Lord Beecham, or the matters referred to by Baroness Sherlock, or by the noble Lord Thomas. Now, other noble lords have spoken about injustice, about unfairness. They are, of course, absolutely right to raise this. But in my world, we seek fairness not only because it's morally right, but because once it is absent, harm starts to happen. And in the practical business world, when harm starts to happen, things start to go rapidly downhill. So purely to avoid trouble, will the Minister review the fairness and the injustice of the government's decision? It may well be that the government doesn't care for that section of the community that depends on legal aid. And so all the things that we've been saying don't really matter. But I don't think that's the kind of society that we want to live in. It certainly matters to me.
My Lords, my noble friend Lord Haskell raised the question as to why these kinds of cuts were taking place. And I just wanted to quote to you something that was said by the Minister in the Justice Department, Jonathan Ginogly, who's in charge of legal aid. And he said this at the Conservative Party conference last year. And I think it shows an attitude to legal aid, which is to misunderstand it. Jonathan Ginogly seemed to be suggesting that legal aid might be a good way of keeping women busy who wanted to return to work after maternity leave. And the quote I have is that he said, "Legal aid can be a good filler for those lawyers who are out of work, or women who want to get back into the legal job market after having children." Now, Mr. Ginogly, I should tell you all, spent 21 years in practice with the wealthy international commercial law firm S.J. Berwin, and earned the sort of sums of money that we associate with top bankers. And so it may well be that lawyers like himself have no understanding that someone would choose to do legal aid work. not because they're looking to fill in, not because they've come back after having their babies, as indeed I did, but because they actually chose it from the beginning to give voice to those who are usually voiceless within the system. I've spent my life doing legal aid work, and I have done it through choice. And chambers like mine, every year, in fact, win the pro bono awards, despite the fact that all of our lawyers are legal aid lawyers. Why do they win the prizes for pro bono? Because basically their life's experience in the courts gives them the expertise that is necessary in these areas, so that when you come to do pro bono, you're not just filling in or coming like a grandee to offer some kindness and charity to the poor, but you're coming with real expertise about welfare rights, about employment, about what it's like to be poor and on the margins. And so I just want to say, I think the starting point is a starting point that in itself is wrong and to misunderstand the purpose of legal aid. And the purpose was, and it's in that Legal Aid Act of 1949, to make it possible so that no one will be financially unable to prosecute a just and reasonable claim or defend a legal right. I chair Justice, as I've already told the House. And we have a number of concerns, and I'm just going to deal with them very briefly because most of the other contributors to this debate have pointed out the things that I wanted to say. I want to just reinforce that the cuts to the scope of legal aid are particularly going to be damaging in social welfare law, in employment, in housing and education for the most disadvantaged. I'm worried about how it will impact on those with special needs, on those who are mentally ill and so on. Now, some of the ideas in here are really are ones that we have to test and question in this House, because legal aid is not going to be well defended by the public. Generally, if it's health or it's education, the public will rally, but not around legal aid, because they think it is about fat cat lawyers. And the reason for that is because of a combination, a kind of malevolent combination between sometimes government ministers and the media. And it's never been my experience that it's fat cat lawyers who do legal aid work. It's usually that the vast majority of them are committed, decent, good people who are pretty slender and certainly not living high on the hog. But what I wanted to say was that there are a number of ideas here which are certainly worth exploring. For example, the idea of having a call centre which is the first point of access for many people who don't even know how to start about finding a lawyer. But it should be piloted first, because the real concern is that it will fail to deal with those who have low communication skills or complicated cases, as others have said. I'm worried about, for example, the other thing, which is the removal of legal aid for matrimonial cases, because of the inequality of arms it will create for women. Because so often in the courts already, the male spouse is privately represented, and it's the female spouse who is legally aided and represented by a legally aided lawyer, and she will be cut out of it, and it will drive people, as Lord Thomas said, to making allegations of domestic violence, maybe where there has been some domestic violence, but where normally it is not being pursued for strategic reasons, that it might not be good for the children to hear rehearse those the details of what's happened inside the relationship between parents. And I think that we're going to see, if you like, consequences that are undesirable here. I'm also concerned about clinical negligence, because to remove that completely, when the high initial cost of establishing liability is going to mean that poor people who suffer terrible things within our hospitals are not going to be able to sue. So I just want to say these proposals are rushed, and I really do think it's rather like the National Health Service proposals. I think there needs to be some time, and I would ask that there is a little let-up here, and that we examine these proposals before rushing to serious folly and serious consequences for the poor.
My Lords, I'm delighted to have had the opportunity to contribute to this debate and congratulate the noble Lord Beecham on giving us the opportunity to do so. Can I just declare an interest that my daughter is a lawyer practising in legal aid, but I'm not just standing here as a proud father. I actually have an interest in this topic, and concerned, as you will see from what I say in these few minutes, with the knock-on effects in areas such as health and social welfare, which I do indeed know a lot about. As a layman, looking at these proposals, I can see the starting point of reducing dependency on the law and finding better ways to solve disputes seems to me to be a good aim. I can also see that setting priorities and justifying the use of public funds is also entirely appropriate. But as a former permanent secretary, I understand this well, but I also understand that the devil is in the detail and that there will be unintended consequences that must be managed and must be mitigated. And what I think is particularly sad in this case is that these unintended consequences can very clearly be foreseen now. A large part of what is being proposed is about limiting the use of legal aid to crisis points, to the point at which you lose your house, to domestic violence, to serious disrepairs and so on. That begs the question in the first place about how will these be defined and how will they be interpreted, as well as picking up those the very powerful points that were made by Lord Thomas and others about the perverse effects of actually having to up the ante so that the problem is at that level before you can receive any legal advice. But I think there's another point as well, and that is that for many people seeking legal aid, the issue that they're presenting with is one of a complex of other issues. It's not the only problem that they have. Many people have housing problems, they may have health problems, maybe mental health problems, they may be out of work, they may have chaotic lifestyles, or they may just have multiple problems. The point here is that we need to think not just in terms of the seriousness of the issue that is being presented, but also of the scale of the situation and the vulnerability of the people who are presenting the problem. Smaller issues for some people may trip them over into needing much more help. And as I have looked at this issue, I have seen many cases where good legal advice can stop problems and can avoid further litigation. It seems to me that, as other people have said, that there is overwhelming evidence that this can and is the case in many places. The government has also argued in its proposal that alternatives are available, and maybe that is entirely desirable, that there should be alternatives available to reaching for a lawyer when you're in these sort of problems. But are they? There seems to be a great deal of evidence from what other people are saying that there is no guarantee of reliably high-quality advice available elsewhere and indeed everywhere. And I think the point for the government here in making these proposals is that this is an eminently foreseeable problem, is to ask them how they are going to make sure that alternative services for advice and help really are available and really are available to the most vulnerable. And in parenthesis, I very much take the point that is being made about the difficulties of having a single source of entry from a telephone system. I think the reality is when you're dealing with people with multiple problems and multiple issues, you need to be looking at a range of different channels and not just one channel in order to reach them. I also note that the government has done an impact assessment of these proposals, and indeed not only that there are problems that can be foreseen, but that they have indeed foreseen them. There is a long list of possible problems that they raise about social cohesion, about increased criminality, about the impact of resources on other departments, and a recognition, in their words, that failure to resolve one issue may lead to another arising. And on health, they recognise that there may be a potential negative effect on health. Let me just give some very simple examples for which there is plenty of evidence. I think the first one I would do would be to link health and housing. We know that disrepair, damp houses affect health, both mentally and physically, of adults and children. There's research by the LSE for the Department of Health shows that debt advice can not only both lower costs for the health, social care and legal systems, but also reduce the risks of individuals developing mental health problems. So my final words would be about having done that assessment, what is the government going to do about it? And could the Noble Lord, the Minister, explain to us what policies would be put in place to mitigate and manage these problems which are affecting and potentially will affect the health of individuals, and which may be unintended consequences of these policies, but which are foreseeable, and indeed the government itself seems to have foreseen.
My Lords, my noble friend Lord Beecham, when he opened the debate, told us that the government had underestimated the number of people who will be denied funding as a result of its changes in legal aid. The Legal Action Group, who discovered this error, stated that the government had grossly underestimated the impact of its cuts. And the error came about because the government chose to base the impact assessment on statistics from 2008-9, more than a year out of date. And Legal Action Group's director, Steve Hines, described the government as using the most generous interpretation of the data it thought it could get away with. It's clear, my lords, from these findings that the number of people seeking help with legal problems is far higher than the government estimated it would be. And the Law Society's chief executive, Desmond Hudson, said, "It is hard to dispel the suspicion that once again the Ministry of Justice has embarked on a programme of painful change without properly understanding the impact of the proposals." My lords, at present, legal aid is available to the poorest parents of children with special educational needs who appeal against decisions made by their local councils about additional support for their child. And that's as it should be, given the fact that 82% of parents win their appeals and 30% of the appeals are conceded by the local authority even before the case reaches a tribunal. Yet the government now proposes to remove all legal aid where it relates to matters of special educational needs, while discrimination claims will still receive support. For many parents, the only way to get the support their child needs is through appeals to the Special Educational Needs Tribunal, and support will be withdrawn for these appeals. And the government seeks to justify this removal for three main reasons. Firstly, they say that the education of children cannot be accorded the same level of priority as other important issues. Surely, my lords, access to a suitable and challenging education is the right of every child, and if they miss out on such an education, their experience is their disadvantage throughout the rest of their lives. Disabled children already face many barriers in society, and a failure to provide them with a suitable education puts them at an even greater disadvantage. And while the government has taken some welcome steps to support families with disabled children, they threaten to undermine this by withdrawing legal aid, which many families need to ensure that their children get a decent level of education. The importance of providing an appropriate education to all children, especially those with special educational needs, is such that it should be given the same priority as other important issues. Secondly, my lords, the government says it does not believe that parents and carers bringing cases like the ones I've mentioned to be particularly vulnerable. But the Ministry of Justice's own consultation document recognises that disabled children are more likely to live with one or more parents who has a disability. Equally, the parents of disabled children are more likely to be in poverty or to be single-parent families. These facts make nonsense of the government's statement that parents bringing these cases are not likely to be particularly vulnerable. The withdrawal of legal aid in such circumstances risks taking away support from parents who are already financially disadvantaged, and it risks pushing even more families with a disabled child into poverty. That surely renders such parents particularly vulnerable and means that they ought to be given support they need rather than making them victims of these cuts. In addition to making the wrong decision when assessing the vulnerability of parents, the government, in its equality impact assessment, failed to consider the impact of withdrawing legal aid on the children themselves. My lords, 60% of pupils who leave school without GCSEs have special educational needs, and they're not likely to be in education, training or employment at the age of 19. Taking away legal aid from parents and supporting these children, I think, is an absolute disgrace. My lords, finally, the government believes that there are sufficient alternative sources to justify the removal of legal aid in these cases. And to support the argument, the government identifies the Parent Partnership Service, the Advisory Centre for Education and the Independent Parental Service, Special Education Advice Service. First of all, the Advisory Centre and the IPSEA already have more requests than they can cope with, and the Parent Service Partnership are facing huge budget cuts by local authorities, and therefore legal aid will be at threat. My lords, none of the government's reasons for withdrawing legal aid in special education needs stands up to scrutiny, and I hope the government will think again. In a civilised society, this cannot be justified.
My lord,
I also am concerned about the proposed cuts in the provision of civil legal aid, to which a number of members have already referred. In his introduction to the consultation paper, the Justice Secretary claims that the proposals are justified because legal aid has expanded to cases that should not require legal expertise to resolve. In some cases, the right to civil legal aid will be retained: judicial review, homelessness, and domestic violence, among others. On the downside, the largest casualty will be private family cases where there is no element of domestic violence or forced marriage. Many women who currently get legal aid for ancillary relief will be directed to mandatory mediation, and that's all. And their former partners, if uncooperative, will simply wait out the inconvenience and continue their intransigence. But, my lords, there is an even worse aspect. Legal aid will be denied in cases of children who have been victims of medical negligence. It is really awful to think that a child who could have been disabled perhaps for life as a result of medical negligence would have no redress. I understand that the government says that no win, no fee arrangements, under such arrangements, child victims will be able to sue for compensation. However, it seems that these arrangements anyway are currently under review by the government. Anyhow, I think it's an entirely unsatisfactory response. Those who lose out will be mainly women and their children and the disabled. Those with disabilities will be disproportionately hit by cuts to areas like clinical negligence and education. And children, such as those fighting cerebral palsy, birth injuries, and those requiring additional educational support, will be cut out of entitlement. In the words of a well-known lawyer writing in Counsel, the Journal of the Bar Council, he says, "The consultative paper destroys the coherent national system of legal advice and replaces it with a hideously complicated list of entitlements and restrictions." He concludes, "It is outrageous that 500,000 people on benefit incomes or just above will lose entitlement to legal aid because of the excesses of bankers with staggering incomes, and it may be the incompetence of those managing government finances." I agree with that. The government really must think again, particularly with regard to the likely effect upon the most vulnerable, children and the disabled. There is a section of the consultative paper dealing with employment, and here the government seems really rather confused. The paper refers to user-friendly procedures available via the tribunals, where individuals can effectively represent themselves, so there is no need at all to provide legal aid in an employment context. The present arrangements are described in glowing terms. However, over at the Department for Business, Innovations and Skills, an entirely different view is taken. The Business Secretary is now in favour of proposals making it easier for employers to dismiss workers and more difficult for workers to make claims for unfair dismissal. To get to a tribunal at all, a worker will have to pay a fee, and perhaps a large one. And it won't be the nice, friendly tribunal envisaged in the Justice Secretary's paper. Oh no. The lay-sides persons currently on tribunals, representative of both sides of industry, are to be withdrawn. The unemployed worker must put his case to a judge sitting alone. So a so-called nice, friendly setup is to be transformed into an entirely legal one, with, of course, no assistance provided. My lords, there's only one sort of advice I could give to an employee. If you are not yet a member of a trade union, join one as soon as you can. Unions are skilled at representing their members, and the government is introducing an environment in which you will need all the protection you can get.
My lords, in the time available, I want to make 3 points about the proposed cuts to civil legal aid. Firstly, these cuts target the poorest, but reduce standards for all of us. Secondly, the cuts in their present form actually increase costs to the taxpayer. Thirdly, not only do they restrict access to justice, but they specifically remove legal aid, as we've heard, from children who are victims of medical accidents or negligence. I find this almost unbelievable. who in their right mind would think it was an acceptable idea to remove legal aid from a child who's been disabled for life due to a medical accident or, still worse, negligence? Now, I've written to all noble lords asking them to write to the Prime Minister on this point because I feel so strongly about it. And this is because regardless of our politics, I don't believe there is a single one of us in this House that thinks that is a good and proper thing to do. I hope that all of us believe Great Britain should be a country that provides legal aid to children who are victims in these circumstances, not a country that would deny those children any recourse to justice. So, giving members on the government benches the benefit of the doubt, what on earth is this about? Even more perplexingly, it's not just about saving money. Because if it was, the government would welcome with open arms the Law Society's proposals. They actually cut more than the government's £350 million cuts to legal aid, as we've heard. The Law Society, playing an excellent hand of poker, has raised the government's cuts and said, we'll cut even more. So if it is about saving money, why can't we take on board the expertise of those that actually work in the sector? Because critically, their cuts do not involve removing recourse to justice from the most vulnerable. And now to perhaps the most salient point. It's not just the poorest who will suffer. We'll all suffer. Because if we don't have legal aid, for example, to challenge Rahman-type housing, then housing standards don't improve. If we don't have legal aid to challenge, as I've said, medical negligence, then care in the health service overall won't improve. And we see how case law in Britain protects all British people. Look at the Hillsborough disaster. Look at the thalidomide case. Look at the Clapham rail crash. All had elements of civil legal aid and led to safety improvements, whether it was for healthcare, for stadium safety, or for transport. So although it is only the poorest who evidently qualify for civil legal aid, the resulting case law protects us all, and we will all be worse off if this goes through as it is currently planned to. So I do ask the government to think again. I ask for intelligent cuts. None of us think no cuts should be made, but not self-inflicted cuts that will wound this country grievously. And I do want to ask the Minister a particular point. If the Minister could reply to actually bring some clarity to the Green Paper. It does say on page 172 that we propose to retain the current scope of legal help and representation covering legal aid for medical negligence. It has a few more words than that, but that's essentially what it says. And then it goes on to say we propose to remove all legal help and representation, again with a lot more words, but around medical negligence. So which is it? Now, I know the government has said, oh, it was an accident. Actually, we do not mean to give children that cover. But the good thing about such a contradictory Green Paper is that the government can do a U-turn and say, oh, that's what we were thinking all along. So that's what I hope the government will do. Please step back from these proposals. It's bad enough to remove help from the most vulnerable, but to do that when it seems clear it will increase costs to other departments, frankly, seems insane. And I will write to the Minister with a full list of examples of how costs are going to increase in other departments. So my last sentence really is that I fully realise here in the House the law we often pass most often is that of unintended consequences, but here the consequences are clear, and I implore the Minister to commission an impact assessment before going further with something that could severely damage this country's fantastic justice system.
My Lords, I thank my noble friend Lord Beecham for instigating this debate, and of course for all noble lords who have spoken in it. My Lords, there can be no doubt that this debate is both timely and vital. Timely because the government is, we are told, close to announcing its decisions on its consultation paper of last November. Vital, because if the government sticks to its Green Paper proposals, then the system of social welfare legal aid will be decimated, if not destroyed. It's as serious as that. Nearly 750,000 people will no longer be eligible for legal help. Huge swathes of social welfare law in housing, in debt, in education and in employment will be declared out of scope, and legal help that catches problems early will no longer be available in many cases, and the eventual cost to the state, as we've heard in this debate, will be much, much higher. My Lords, these proposals are really nothing short of an attack on the poor, no more, no less. They're the wrong cuts at the wrong time and hurting the wrong people. It's therefore hardly surprising that many groups have banded together to try and persuade the government to just think again. This debate, my Lords, is part of that process. I pay tribute, if I may, to Justice for All, the umbrella group covering a lot of other groups who have taken up this cause, of course to the Law Society and to the Bar Council, and to many members of another place of all political parties who have said, firstly, this is wrong, secondly, that there are alternatives, and thirdly, that to implement the proposals as they stand would be disastrous, uncivilised, discriminatory and hugely counterproductive. My Lords, of course there must be some cuts. We accepted that in government and we accept it now. And indeed we did cut, controversially in some cases, some legal aid. If returned at the last election, we would have made some cuts. Not as many nor as fast as these proposals. The cuts would probably have been in the field of criminal law. They would have been as a result of our white paper, Restructuring the Delivery of Criminal Defence Services, published in March 2010. They would have been controversial, but they would have been substantial, but not as substantial as these. But, my Lords, the point is that whilst in government, we refused point blank to cut social welfare law, and indeed we increased it. One figure from £151 million in 07-08 to 208.4 million in our last year, 2009-10. My Lords, we also raised the financial eligibility limit for civil legal aid by 5% in 2009, making it possible for many more to legally receive the help they need. Now, of course, one of these proposals is for the government to cut eligibility significantly. And one of the other things that we did do, and perhaps the thing I'm most proud of in my time as a junior minister, is we saved South West London Law Centre from closure. Why did we do all this? Firstly, it's a time of economic difficulty. It's madness to cut legal help to people in this way, something the government intends to do. But more importantly, because if legal aid doesn't give access, or some access at least, to justice to those who are dispossessed or disadvantaged, whether through poverty or bad housing or unemployment or low wages, because of the colour of their skin or their mental and physical health, what is the point of a legal aid system? The case has perhaps never been as well put as by the new Conservative Member of Parliament for Maidstone and Weald, Helen Grant, in an article in a national newspaper in February this year, and I quote, "As civil liberty is to the freedom of our nation, civil legal aid is to the protection of its citizens. For some of our most vulnerable people, it is the only sword and shield in their armoury." My Lords, common sense and the expert research that was referred to by my noble friend Lord Hart, of Professor Hazel Jenn and others, tell us this. We know that early legal advice changes lives. We know that legal problems come in clusters and not singly. We know that lack of such early and comprehensive advice can lead to problems escalating out of control, leading to relationship breakdown, unpaid and hopeless debts, and sometimes a decline into crime, and all the misery that brings with it. Yet, my lords, that will be, I fear, one of the almost inevitable results of these proposals if implemented. And then, of course, the cost to the state, to all of us, the taxpayer, where no legal help is given. The figures that the CAB put out about the savings by spending £1 of legal aid money were given by my noble friend Lord Beecham in his opening speech. My lords, it is financially so hugely counterproductive. My lords, and the lawyers who practice this type of law, as has been said in the debate, they're not well paid. Some of them have given up the possibility of well-paid and careers in other types of law. And yet the government plans to take 10% from each modest fee that they receive for an act of social welfare advice. We know a number of CABs will not be able to carry on. We know that private solicitors who have been under pressure for some time may be tipped over the edge. But what should also be said clearly, is that the Law Centre movement, which does so much for the dispossessed and underprivileged in our society, is likely to be crushed overall. There's a proposed 77.6% reduction in funding for legal help and an 83.6% reduction planned in the number of legal help cases, all at the same time as local authority spend is falling. Whether it's intended or not, these proposals may well destroy law centres with a disastrous effect on their clients. Now, why these proposals? On the whole, previous Conservative governments have been generous in their support for legal aid. The Liberal Democrats have demanded, and they did demand of us, more money to be spent on legal aid and criticised our cuts. And they, too, have argued for social welfare law. How can ministers have signed up to these proposals? My own view is not that ministers want to play the role of the wicked uncle who wants to destroy anything good that comes across. It's simply, and here I really follow what my noble friend Baroness Kennedy of the Shaw said, it's simply they just don't get it. Their view of legal aid is very limited, is very old-fashioned, so they don't see its relevance to social welfare law. Ministers keep using the mantra that their proposals are to protect the most vulnerable, when quite obviously they are the exact opposite. Their measures, if implemented, my lords, would, far from protecting the most vulnerable, directly harm them. Whatever they do, in the end, Her Majesty's government should stop using this 1984 Orwellian-type misuse of language. In my view, though, the noble minister who is to reply to this debate does get it. His whole history, his whole political history, shows him to be someone who does understand the importance of what is about to be destroyed. My request, our request, for him is to fight these proposals within his department. Don't let these fundamentally anti-liberal measures be implemented. He enjoys a huge reputation in this House, both personally and, of course, politically. If he were to succeed in mitigating these proposals, that reputation would soar even higher. Now, why should he bother, he might ask? Why should he bother? Legal aid isn't his portfolio, it's someone else's portfolio. But the reason why he should bother, my lords, is this, that this isn't fundamentally a legal issue at all. It's not just one for lawyers in government or outside government. And it's not one for non-lawyer ministers and non-lawyers generally to shy away from. It's a simple issue. It's about right or wrong. It's about justice or injustice. In the end, my lords, and I say this to the noble lord, it's a simple question of morality.
Lord Back tempts me. I'm thinking of T.S. Eliot in the Murder in the Cathedral. The fourth temptation is the greatest treason, to do the right thing for the wrong reason. Of course, my objectives in politics, like most people in this House, are of a moral kind. I didn't come into politics to hurt the poor. But there is a fact that, and I'm not in this making the usual party political game, but the fact is that when we came into government, we also came into the biggest financial crisis that this country had faced in 80 years. And Lord Back knows full well, because his own government were planning cuts, that whoever was going to be ministers were going to be faced with tough decisions, hard decisions. To govern is to choose. And every department has had to make tough decisions. And I don't resile from these. And if you are a department which only has 3 big ticket items, prisons, probation and legal aid, and you're asked as part of the contribution to economic recovery to find 2 billion in savings, then you're going to have to look at those 3 big ticket items. In looking at legal aid, we have been tried to look at the scope of the areas that we cover in the most compassionate way. I don't, and I've answered questions before on this, if you have part of your government system that is targeted on the poorest sections of your community, and you cut that budget, then you are going to hurt those sections of the community. And that's the same thing as is happening with local authorities around the country in looking at their various budgets and other departments. It is too easy, and I've got to say, even with Lord Back at the end, not one of the contributions that were made actually put forward a hard choice, as if they were on this side of the dispatch box. It's all right to say that we had plans to raid criminal legal aid, or the Law Society are going to shift it on to the drinks industry, or Lord Haskell is going, I think the jargon is the polluter pays, spread it around Whitehall. But even spreading it around Whitehall leaves the Exchequer with the need to save the money. So, you know, I do understand, and I do not doubt the passion that has been expressed today, and some of the very valid points, and I'll try and deal with specifics as I go through. I understand it. We are still in consultation. I can't say that the consultation is going to produce some poor line conversion at the last moment, because, as I say, we have made a commitment to savings, and we intend to deliver them. What we have tried to do, as I say, is look at the whole philosophy of the system of legal aid, which a number of speakers acknowledged had grown and expanded since its introduction in 1949. I actually went to see Lord Hutchinson, Jeremy Hutchinson from the Liberal benches, who's I think now 96, and in splendid form, although he no longer attends, but he was part of that generation that formed the original Hay. And he said to me, our hope then was to create the parallel legal system to the National Health Service. I don't doubt what was behind and is behind the legal aid system. We share that. The consultation that we put out has produced nearly 4,800 responses in total. I can't give the detailed government response today. We will be announcing that in the next few weeks. And I can assure you that what has been said and the various points made will be fed back into that consultation. Before addressing the particular points made in the debate, I wish to reiterate briefly some of the considerations the government bore in mind in making these proposals. The context of the government's overall reform is, as I've said, to tackle the deficit we inherited on entering office. Last October, the spending review set out the scale of the challenge facing the Ministry of Justice. However, as the government has stressed, we know that our policy cannot simply be determined by dealing with the deficit, and neither are we doing so. There is considerable potential for reform within the justice system. Our legal structures and our legal aid system are capable of reform. So financial considerations and the need for reform come together. There are many reasons why we believe it necessary to reform legal aid, many of which have been acknowledged today. Since the modern legal aid system was established, its scope has been widened far beyond what was originally intended. By 1999, legal aid funding was available for virtually every type of potential issue, including some which should not require any legal expertise to resolve. The scheme now costs over $2 billion a year, making it one of the most comprehensive schemes in the world, even taking jurisdictional differences into account. And we need to understand that even after reform, we will still have one of the most expensive schemes in the world. In developing our legal aid reform proposals, we went back to basic principles to make choices about which issues are of sufficient priority to justify the use of public funds, subject to public means and the merit test. The proposals in the consultation paper aim to take into account the importance of the issues at stake, the litigants' ability to present their own case, the availability of alternative sources of funding, and on alternative routes to resolving disputes, as well as our domestic and legal obligations. To focus financial support on the areas where it is most appropriate and most necessary, the proposed reforms involve significant change to the scope of legal aid funding. We did not propose any change to the scope of criminal legal aid, and it was also proposed that legal aid will still be routinely available, as a number of colleagues have said, in civil and family cases where people's liberty is at stake or where they are at risk of serious physical harm or immediate loss of their home. For example, we propose to retain legal aid for asylum cases, for debt and housing matters where someone's home is at immediate risk, and for mental health cases. Legal aid will still be provided where people face intervention from the state in their family affairs that may result in their children being taken into care. For cases involving domestic violence, and I note the comments that have been made on that, or forced marriages, and I'll deal with that later, and for immigration cases, where the appellant's liberty is at stake. We also propose that legal aid should be available for cases where people seek to hold the state to account by judicial review, and for the cases involving discrimination that are currently in scope. Legal help to bereaved families and inquests would also remain in scope. However, prioritising those areas requires that we make clear choices about the availability of legal aid in other areas. We therefore propose to remove from scope of the scheme issues that are not, relatively speaking, of sufficient priority to justify funding at the taxpayer's expense. We propose to cease providing legal aid support for private family law cases unless domestic violence, forced marriage or child abduction is involved. Too often the long drawn-out acrimonious nature of court proceedings exacerbates disputes between couples rather than solving them. Under our proposals, we would continue to provide funding for mediation, to encourage couples to use more effectively methods to resolve issues between themselves rather than using the court. We are not proposing mediation as a cure-all in place of litigation, and I will say more of that shortly. The Government further proposes to remove from scope of civil legal aid schemes claims of clinical negligence, where in many cases alternative sources of funding are available, such as no-win, no-fee arrangements. Again, I note the points that were made on that. We also propose to remove from scope the categories of employment, education, immigration, some debt and housing issues, and welfare benefits. Exceptions will be made for some of these cases where there is a risk of anyone's safety or liberty, a risk of homelessness or discrimination. In many of these cases, the issues are not necessarily of legal nature, but require information, practical advice, or other forms of expertise to resolve. We recognise that there would be some cases within the areas of law we propose to remove from scope, which international or domestic law would require to be funded by the taxpayer. We therefore propose a new exceptional funding scheme for excluded cases. But can I say to my noble friend, old folk, we will take a very hard look at issues on the international side of things. It won't be an open checkbook on that. The impact of the reforms on existing claimants and various groups who would no longer have access to legal aid is something that we are looking at. We recognise that there would be some impact of the proposals on existing claimants or various groups if issues were no longer to fall within the scope of legal aid. However, this does not mean people would be unable to resolve their issues. Straightforward mechanisms are often available to assist. For example, in many tribunals, such as employment, legal representation is not currently available because they are designed to be used without legal aid. We published an initial impact assessment and an equality assessment alongside our consultation, and when we publish the final response, we will also push, partly in answer to Lord Tui's point, we will update the impact assessments. There is limited evidence about the impact of proposals on the case length of litigants in person, and the findings are mixed. We do seek to simplify procedures. The forms and guidance available to those using the court in person. We do recognise that mediation may not be appropriate for all individuals, but it is important for them to consider it as an option, and we are currently making it easier for individuals to do so. When successful, mediation may hold considerable advantages, as it can be cheaper, quicker and less acrimonious process than those contested court proceedings. Public funding for family mediation has been made available for more than a decade. This has proven to be a successful policy. With effect from 6th of April, we introduced a pre-application protocol for family mediation information assessment meetings. Any individual, self-funded or public-funded, will be expected to consider mediation before beginning proceedings. However, family proceedings in relation to domestic violence or emergency proceedings are expressly outside the scope of this requirement. This is a big step forward to improving awareness and encouraging take-up of family mediation. On civil mediation, the Government is currently consulting on the paper Solving Disputes in the County Courts, Creating a Simpler, Quicker and More Proportionate System. The proposals are to require all cases below the small claims limit to attempt settlement by mediation before being considered for hearing, and the introduction of mediation information and assessment sessions for claims above the small claims limit. We recognise that we cannot, of course, compel parties to settle, but we can create a better environment within which settlement can be explored. This consultation closes on the 30th of June. My Lords, if I could look at some of the specific issues that I haven't covered in that. Some of the points made, for example, by Baroness Sherlock on asking for a time lag, I'm not sure that that is something that can be done, but I will feed that back to colleagues. The question of clinical negligence, and that point was raised by Lord Foulkes and a number of other colleagues around the House, including my colleague Lord Thomas of Gresford. This will undoubtedly be a matter of some debate when legislation reaches both the other place and here. The confidence that the CFAs will cover that area is something that is going to be, I'm sure, very hotly debated, and we can certainly reconsult Lord Justice Jackson on that. The Lord Dubs was concerned about forced marriages. I think that I better just double check before I sell the pass on this, but I think that the forced marriages will remain within scope. We propose to keep legal aid for these cases, including the power to waive the upper financial eligibility in these cases. So I hope that helps. I fully acknowledge the point that Lord Hart made about the pro bono help from the legal profession. But it's, and what we will look at the question of advice deserts. I mean, that is something that has been raised, and we will look at that as a matter of concern. Lord Haskell, as I say, it's a neat option to the polluter pays, but in the end, the Treasury wants its money. But we are looking at the evidence given by the Law Society, the point that Lord Beecham mentioned, and we will give consideration and publish our responses in due course. I take the point that my noble friend Lord Thomas made about people inserting domestic violence to get themselves in scope, and that would have to be advised. Baroness Sherlock emphasised the need for advice. I suppose where we differ is whether what the advice is always needed is legal advice, and whether we in fact force people into legal advice. Going back to Lord Foulkes, I mentioned that we will look very hard at requests under the human rights issues, and the government wants funding on only serious and significant cases. I will also feed back his concerns, as expressed by others, about clinical medical negligence. With Baroness King, the consultation paper was clear, and I was passed it up, it's around here somewhere, and it does clearly say that we were going to take clinical negligence out of scope, and that says it very clearly in the document. If she sees a contradiction, I'll be happy to talk to her about it, and quite clearly, because I too received her letter, there is going to be a campaign on that. Lord Listowel asked for assurance about children who need separate representation in family cases. Yes, we propose to keep legal aid for children where they have been made a party for the case in family proceedings. Baroness Kennedy took some cheap shots at my friend Jonathan Gianogli, who is a very, very good solicitor. He's a very good solicitor. And Lord Crisp, as a former permanent Under-Secretary, I give full deference to his advice, but I'm sure in a long and distinguished career, he must too have sat there with a Treasury demand notice and a programme of cuts to be pushed through. On special educational needs, Lord Toohey's point, special educational need tribunals have been designed to be easy and accessible, and we're considering the points he made during consultation. I'm now being tugged at that my time is up, because if there are points that have been made that I have not yet had a chance to raise, I will write to colleagues. Like Lord Buck, I agree this has been an extremely timely debate because we are still in consultation, and it has been an extremely useful one because those who have contributed from real expertise and real commitment. We are listening. We have some tough decisions to take. We will not flinch from those tough decisions, but neither will we ignore common sense when it's offered to us.
I thank those of your lordships who have contributed so seriously and constructively to this debate, and indeed to some members of your lordships' house who had indicated interest and support but were unable to attend, and I cite particularly Noble Lord Newton of Braintree, who very much wished to have been here. And I extend those thanks and indeed my sympathy to the Noble Lord, the Minister, who has been struggling manfully with the constraints of collective responsibility, or some of us would say collective irresponsibility. I hope he will take back, I'm sure he will take back the opinions, the facts, the suggestions contained in today's debate, and we will see at least some of them reflected in the legislation which is wending its way towards us. In those circumstances, my Lords, I beg leave to withdraw the motion.
Is it your Lordship's pleasure that the motion be withdrawn? It is by leave withdrawn.